I'm Reagan.
And I'm Aspen, and we're presenting The Road to Justice, Brown versus Board of Education. Today, December 17th, 1953, we will be taking a look inside the Supreme Court where Thurgood Marshall and I, Paul Wilson, will be arguing our sides of Brown versus Board of Education once more. I will be defending segregation in schools, and my opponent, Mr. Marshall, represents the side of desegregating schools. As you can see, there is a significant barrier standing between African Americans and whites. Let's see how this case plays out.
Hello folks, I'm Thurgood Marshall, better known as Mr. Civil Rights. I'm an attorney and a very successful one, I like to think. Although we have already argued this court case before the Supreme Court, we'll be doing so again, and this time in the presence of Chief Justice Earl Warren. Today is the most important case I will argue for with the hopes to end segregation in schools.
And that would make me Paul E. Wilson. I am a defender of segregation, among many other things. Previously, we argued this case on December 9th, 1952, in the presence of Chief Justice Fred Vinson. After the hearing, the justices of the court were deeply divided and had not made a decision by June 1953, which was the end of the court's term. So they decided to rehear the case today, and while I may not completely agree with segregation in schools, it is my duty to defend the laws of my state. So let's begin.
Brown versus Board of Education has reached here the Supreme Court by the courageous efforts of lawyers, community activists, parents, students, and many others that stand up against injustice with me. My hopes are not only to make a better name for myself, but to help my country.
Well, according to Plessy v. Ferguson, the Equal Protection Clause of our Constitution does not require integration in schools. The states have already begun a good faith to make all their facilities equal, and the continuance of inequality among the races is merely because African Americans still need time to overcome the effects of slavery.
Mr. Wilson's statement about promises to making the facilities equal is clearly false when looking at the Davis v. County School Board case from Virginia. These schools are distinctively unequal, as shown in these pictures. Here you can see in Exhibit A, the schools for the colored students. In comparison to Exhibit B, the facilities for the white students are deplorable. There should be no segregation amongst American citizens. We are all equal on the inside, and this injustice is just unacceptable.
The U.S. District Court unanimously rejected the students' request of building new schools in Virginia due to poor conditions of their existing ones, and stated they have found no hurt or harm with the effects of segregated schools.
There is much harm that comes with segregation in schools, Your Honor. How is it for when white students get to attend these sophisticated school buildings while colored students are having to attend these tiny shacks as makeshift schools? And yet we are all American citizens.
I agree there are some inequalities among schools in the South, but let's refer to Topeka, Kansas, where all the school buildings get equal funding, identical facilities, well-qualified teachers, and students that receive the same education regardless the color of their skin.
Mr. Wilson is correct. However, the physical differences between the schools is not the problem here. The problem is that these students are being punished for something they cannot control themselves. Why is the color of their skin a factor on what type of education they shall receive? Segregation by race greatly diminishes African American self-esteem they have for themselves.
The type of education white children receive in Topeka is the same kind of education African Americans receive in Topeka.
The badge of inferiority is given to minority children by segregation, hindering their development no matter how equal these facilities might be. The Topeka Board of Education operates under the 75-year-old law, schools in unorganized counties. That permits but does not require segregation. Our educational system is being operated by a law that seemed fitting 75 years ago, but even then they did not require racial segregation, and yet African Americans are still enduring the painful effects of segregation today.
Sir, it is shown that there is no law that is being broken when children are segregated by race in places of education, Your Honor. That is the law.
This separation of schools makes these colored kids feel less and inferior. How is this a good environment for these students to learn in?
How is the environment providing a negative effect when clearly these schools are equal in every possible way? Schools for the colored have well-qualified teachers. They even receive the same textbooks as the white children. Here you can see in Exhibit C and D that both African Americans and whites are using the same resources in both schools, thus making this separate but equal.
Just because students may use the same resources for education in some places, it doesn't mean that it won't affect these colored students. Segregation violates the individual rights under the 14th Amendment. It clearly states, that no state shall deny to any person within its jurisdiction the equal protection of the law. No state can treat certain people different than others, meaning one race cannot have advantages over the other. In the eye of the law, all Americans are equal.
Yes, that is true. No state shall deny any person. Keywords, no state. But Washington, D.C. isn't a state. It's the District of Columbia. Therefore, the 14th Amendment does not apply to Washington, D.C. The 14th Amendment was never made to force African Americans and whites to attend the same schools. It was made for all things to be equal amongst the citizens. Separate but equal schools should be respected.
As Mr. Wilson stated, the 14th Amendment does not apply to the Boren v. Sharp court case from the District of Columbia in some eyes. However, there are still many problems with segregation in schools, Your Honor. This African American community here in D.C. has very limited and overcrowded schools. These schools are so overcrowded that they are forced to provide half a day of education. This means that these students only receive half days of school. How is this good for their education and growth?
However, not all states are dealing with this problem, Your Honor. Let's get back to the point at hand. Many schools like the ones in Topeka are perfectly equal and have no physical differences, thus making them separate but equal, like how we believe the law was intended to do.
The object of the 14th Amendment was undoubtedly to enforce equality amongst the races.
Respectfully, sir, I disagree. I believe the 14th Amendment was made to make all things equal amongst the citizens but separate. Topeka is a perfect example of this. By the United States District Court, these schools are to be found of equal quality.
Brown v. Board of Education is made up of 5 cases, not just one. So let's discuss the Belton v. Gebhardt case from Delaware. These African American families are struggling with locations and transportation to schools. These students are having to walk miles to school every day, while a white school is just a couple blocks away.
While some may think this is unfair, these schools are still separate but equal.
How can you say this is separate but equal? Look at the Briggs v. Elliott court case from South Carolina, where you're receiving the same complaints about transportation to schools. Why is there not a solution to this problem?
The solution has already been found, so these schools may need some alterations. That does not mean segregation is wrong.
This is more than asserting to a principle, Your Honor. It is ending a practice in which demolishes African American self-esteem they have for themselves. Do we really want to live in a country where people are mistreated and looked over by the virtue of their skin? Such a system shouldn't be legally permissible.
Think about all the African American teachers that would lose their jobs and find themselves unemployed if we integrated schools. What would we do then?
If the schools are integrated, the African American teachers would teach at integrated schools. The only justification for continuing to have segregation in schools is to keep people who were slaves as near to that stage as possible. A simple doll test that we have conducted has clearly shown that segregation is psychologically detrimental and these effects last a lifetime. This must come to an end.
As you can see, the barrier of segregation between African Americans and whites still stands. The argument is now over, and we must now wait for the opinion of the court. We will now take a moment to examine what we have witnessed so far. Thurgood Marshall has made points on how segregation makes some children feel less than and inferior. I then countered his claim by stating that African Americans still need time to overcome the effects of slavery. Mr. Marshall made his final statements concerning the psychological effects segregation has on children. Today is now May 17, 1954, the day of the court's final decision.
Today, May 17th of 1954, the Supreme Court made the unanimous decision to end segregation in schools. Chief Justice Earl Warren said, "In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education, such an opportunity that the states have undertaken to provide it. It is a right which must be made available to all on equal terms. In the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal." Today, May 17th of 1954, the Supreme Court decision broke the barrier between white and African American students in the place of education. The barrier of segregation no longer stands. This is a monumental day that will be remembered for many years to come. The court is adjourned.